Well,
I warned you.
well, thank you. Thank you again for that. It's nice to be here. It's a great community, by the way, that you live in, and so it's nice to be able to talk to you. As she so well put, I am an attorney, and so I specialize in the areas of estate planning, asset protection, elder law, business law, and succession primarily. I have been practicing for almost 20 years, actually 20 years, 22 years to be exact. And this is a field, these fields are the areas that I focused in on entirely since I've been a practicing attorney, as well as when I established my own firm many years ago. Our particular firm is a boutique practice. We specialize in those areas, and we have offices in DC and Northern Virginia, of course, and then an office in Hampton Roads as well. I am licensed to practice in DC and Virginia. And so we have 45 minutes. What I plan on doing today is primarily talking about trusts, as well as estate planning basics in general. It's always a good idea to have the basics down first, meaning what's a will, what's a power of attorney, that we'll lightly touch upon, and then get into trust planning. Because in some, there are really three ways to handle your estate. Do nothing, which is what most people have as far as an estate plan. And there's no estate planning shaming, by the way, because in many cases, why would you want to talk to a lawyer, number one? Why would you want to talk to a lawyer about death and incapacity? It's not a fun topic. So I understand why most people kind of kick the can down the road in that regard. The second option is that when most people think about getting an estate plan, it's getting a will, right? So there's the will plan, which I will talk about. And the third option you have in estate planning would be the trust plan, okay? So those are really your three options in your estate planning field of selection that you have to go through. So we're gonna go through all these, and I'm gonna touch on some key aspects with this, okay? So if you have questions, I will try to get through this pretty quickly, and to be able to save time toward the latter half of the presentation so that you can indeed ask questions. As a favor to the village, you're more than welcome to email me, to call the office, to essentially do, contact me however shape or form you want, and you will not be fearful of a fee, okay? So you have that as well in case you have some questions. And let me just see here, because I think I might have pulled up the Osher one by mistake. So let me, if you don't mind. Sorry about that. I was having some technical issues when I first popped up here, and I had two of them up. And let me just see which one this is. Okay, so this is right. All right, sorry about that.
No worries. It actually allowed a few more people to join us.
Perfect. So usually when I teach at Osher, I've kind of combined, because when I teach at Osher, particularly with American University in DC, I pitched it to be more DC oriented in terms of the plan, although it affects people in adjoining states as well. So it's very applicable. Usually I have a 2-session, or I have 4 sessions. And so I kind of whittled down the 2-session into just 45 minutes. So you're getting a lot of information over a short period of time. So thanks for that. So do you know that 50% of Americans pass away without any planning whatsoever? That means not a will, not even a power of attorney during incapacity, and even an advance medical directive for medical decisions. That is an epidemic, really, in terms of not planning in general. So we want to make sure that you have a plan, number one. And believe it or not, most plans that are in existence today, over 70% haven't updated in quite a few years. And these estate plans really need to be reviewed if you have one, at least, on your own, in your own house, if you will, every year. And then perhaps at least every 5 years, checking with your estate plan attorney, because there are changes to the law as time goes on. These documents, if the attorney is doing their job, they're updating them as time goes on with new laws, their new tax laws that come into effect. So you certainly just don't want to rely on a 20-year-old plan that you might have when your kids are minors, for instance. Well, since most people don't plan, what are the possible implications of this? And typically you'd have, as you might imagine, frustrated and fractured beneficiaries. You have court battles over the care of a loved one during incapacity. You have thousands, if not in some cases, tens of thousands of dollars in litigation costs, and thousands, if not hundreds of thousands, or in some of the examples I'm about to show you, millions of dollars to the IRS for estate taxes. Or if you live in DC, of course, DC has its own separate estate tax rate, which I will discuss in a few minutes. What is an estate? And again, some of you might have an estate already, estate plan already. Some of you might have a trust already. And but just bear with me a little bit, because some people in our virtual room here don't have the basics down a bit. And so again, we want to kind of have a two-step process before I dive right into trust planning. So what is an estate? Well, it's pretty common sense. It's your house, your checking account, savings account, insurance documents, death benefits, cash value of those policies, personal property items, and the like. So all those items need to be prepared for, okay, for incapacity and when you pass away. Pretty common sense why you need to plan. If you don't have a plan for when you become incapacitated, proper documents in place, that requires your loved ones to go through a court-ordered hearing called a guardianship or conservatorship, which I'll touch on lightly in a few minutes, at great cost, at great expense, and quite honestly, great angst to your family members. Who controls your assets at death? If you don't have a plan, DC has a plan for you, for instance, and it may not be the plan via their code or via the laws of DC that you may prefer, right? And so you want to make sure you've planned your estate in terms of who does what and who gets what, not the District of Columbia, or if you live in Virginia, the Commonwealth of Virginia, or some people may have connections with Maryland, for instance. Who needs estate plan? This seems commonsensical as well. Couples need estate plan. The issue with couples are typically for estate plan attorneys is they tend to rely on the fact they co-own everything together. That's kind of a side benefit to co-owning property, right? If you own real estate in the district and you pass away and you're married, that interest vests to your surviving spouse. There's no will needed, there's no trust needed. It's pretty obvious or pretty clear. The problem is that because married couples rely on that fact, when one passes away, the surviving spouse typically doesn't do anything either. And that's when you have a big problem with a kind of a court process called probate, which I'll talk about in a couple minutes. Young families, maybe not so much demographic here, but young families, if you have children, you need to ask them or inquire them, hey, look, if you pass away, who do you have a guardian appointed to be the legal parent of those minor grandbabies of mine? Because I don't want to have to fight it out with the in-laws in court as far as who's going to be taking care and making legal decisions for those grandchild of mine. Single people, sometimes they don't plan because they're just single, and single people, because they don't have the luxury of co-ownership being married, they need to plan oftentimes more than married couples, at least from the first stage of things. I pick on celebrities a lot whenever I present, and this is an older celebrity example, but Casey Kasem, most of you probably remember who he was, the great voice of radio and TV. Well, celebrities are just like us. The stats are basically the same. They don't plan either, despite the fact they're typically lawyered up around them in terms of different contracts and royalties and all the things they sign. It amazes me all the time, these celebrities that pass away and they have no plan. If they have a plan, it's really bad. So in this instance, Casey became incapacitated, did not have any legal documents in place. His wife from the second marriage filed in court to get a guardianship. Typically the daughter, and this usually happens, the daughter from the first marriage contested the second wife's ability to control Casey's money. There was a big blow up. A lot of attorneys made a lot of money off this particular case. But the reality is, had Casey designed a plan, it would have made things a lot more simpler for the surviving spouse, or maybe the child, if that's who he wanted to step in should he become incapacitated. Joan Rivers, a comedian, yes, but she didn't take her estate as a laughing matter. She did have an advanced medical directive. So this is a good example of, as you probably will know, Joan had many operations. And during the final one, there was a complication. Her daughter was able to make a proper medical decision for her to allow Joan to die naturally and with dignity, okay? So that's an example of a good plan. Well, there are primarily, excuse me. Okay, perfect. The Zoom, for some reason, the Zoom lens or Zoom pictures showed all your faces, which are a great looking group, but I couldn't see my PowerPoint, so I had to adjust it. There are 6 common estate plans. There's the will plan. There's the do nothing plan, which most of us rely on. There's the joint ownership plan. The giving assets away plan. There's beneficiary transfers. Typically, you have those set up through IRA companies or life insurance, for example. And then there are trusts, okay? So we're going to talk about all of these as we go through it. And my PowerPoint's sticking. There we go. The do nothing plan. This guy is probably the executor or administrator that had to step into the estate because the person passed away without a plan. Sometimes it's a lawyer, believe it or not. When people pass away, unfortunately, they bring in the family members bring in a box of junk, oftentimes a law firm, and it's got papers, it's got bills, it's got a whole host of things that the son or daughter really doesn't know what to do with, and they're frustrated. So if you don't have a plan, the DC courts have a plan for you, and it's distributed in accordance with state law. And so that really depends on a lot of variables. You know, if you have a blended family, the estate could be distributed one way. If you don't have kids, the estate could be distributed a different way. And so typically you want to make sure you at least have a plan to decide who gets what and who does what. All right. If you don't have a plan for incapacity, a court process must be engaged where a loved one has to hire a lawyer at great expense to get a court order to allow even a spouse in many cases to make legal and or financial decisions and or medical decisions for a loved one. I'll give you a prime example before I move on to the celebrity example. You do not have as a spouse the innate authority to make the decision to withdraw life support if your spouse is incapacitated and suffering from a persistent vegetative state. We saw a dire example of that many years ago with the Terri Schiavo case, where Terri Schiavo, a Florida resident, didn't have any documents in place. She became incapacitated, and her husband wanted to withdraw life support. Her family did not. A lot of court battles. Eventually, the Supreme Court of Florida sided with the husband. But the reality is, if you don't have that document, it requires your loved one to go to court, and you can't, again, rely on the fact you're married, that you somehow have some innate decision tree ability to make financial and medical decisions overall, okay? Especially out of the box financial and legal decisions and medical decisions. Howard, I don't know, maybe the Elon Musk of his time, I don't know. But he passed away. Again, another celebrity, didn't have a plan. Eventually, the courts decided to distribute out among 22 of his cousins. I would say if Howard had a say, he probably would not want that type of distribution. And again, all the importance of planning for your own estate. One last celebrity example, and I promise you not to pepper you one for a while, but Prince, a more recent example, probably over, at least maybe close to over 100 million, $1 billion actually, in terms of total assets at this point. Didn't have a will. Had he got proper estate planning counsel, he could have avoided probate and probably could have diminished a great deal of the estate tax liability that ultimately the IRS got from his estate. So again, unfortunately, he didn't have a plan either. Let's take a look at joint ownership. This is typically what we rely on by default if we're married, right? You own a bank account together as joint owners. One passes away, the surviving spouse is the sole owner. If you co-own real estate together, one passes away, the remaining owners owns the property, typically depending on how the deed's drafted. So that's kind of an innate estate plan, if you want to call it that. The problem with relying on joint ownership alone is stats say that Tom and Ann's not going to have a plan. Well, Tom dies, stats also say Ann's not going to get a plan either. Why should she? Didn't have to go through probate. Everything was co-owned. But when Anne passes away, the problem is her family would have to go through probate. So in essence, they're just kicking the can down the road. You know, I don't know, it must be a guy thing, but a lot of times when estate plan attorneys meet with their clients and they're married, it's usually the husband that says, oh, I don't care, let her deal with it. And that's really not an estate plan, okay? And what I tell couples is that you want to plan while both of you are alive, because you have to look at your estate plan not so much as a burden in terms of its development, but an ability to leave a legacy for your kids, for charities. And you find when you're kind of going through the kitchen, if you will, cooking up an estate plan with a married couple, is that it brings up things that the other spouse didn't know about. Oh, I had no idea you had a passion for that charity. I had no idea you didn't trust our one son, that you want to hold back assets and trust for his benefit. And so again, you just don't simply want to rely on the surviving spouse to make those decisions for you, okay? The other problem about planning is that more and more people, and I have a stat for this, but I didn't include it in this particular presentation for time, but more and more people are getting remarried, particularly my older clients. It happens all the time. And so the problem of not planning, if you pass away and your surviving spouse gets remarried, there's nothing preventing them from disinheriting your kids. There's nothing preventing them from quoting, marrying, quote, the Black Widow, and the kids being disenfranchised or disinherited from the estate plan. With your estate plan attorney, there is a way while you're both alive and of course married to design a plan to protect against remarriage. So definitely something that you want to talk about, if that's a concern, that you want to talk about with your estate plan attorney when you develop a plan. So as you can see in summary, joint ownership only postpones probate. It unintentionally disinherits or possibly could intentionally disinherit a loved one. And incapacity, again, joint ownership is great, but in many jurisdictions, if you co-own property together and the husband's incapacitated because of dementia, and you want to sell the property, in many cases, a closing attorney will say, well, do you have a power of attorney to sell your husband's property, half of his interest? And you'll say, well, no, he's my spouse. I can sell it, right? I mean, he doesn't care. Trust me, and I'm a spouse. Well, that's not going to cut it. You're going to need a power of attorney signed by him, allowing you to make those types of decisions for him. So again, joint ownership as a reliance doesn't help at all when it comes to incapacity. It's kind of like a situation when you add a co-owner, particularly your kids, to real estate, which I'll talk about the pitfalls in a minute. But once you add a co-owner to a deed or a bank account, it's hard to get them removed, right? They have to agree to be removed. In some cases, I've seen some kids not wanting to sign that document. Also, too, if you add your kids onto your deed, be a little weary of that, because in some cases, they can have creditor problems that you don't know about. I had a sweet older lady who was a widow. She was selling her house because she couldn't afford it anymore in terms of upkeep, and she was moving to an assisted living. She had gone to her local real estate attorney to add her son onto the deed because, hey, I die, he gets it. I don't need to pay a lawyer to do a will or trust. Probably cost all of $395 to get it done. So when she went to sell the house, the son had to sign too. But the problem was he had a credit card and he never paid on. And the credit card company attached a lien on the house. She didn't know it, but that lien had to be paid off prior to sale. And I could tell you she was not happy about that at all, because she had to sell the property and she was kind of backed into a corner. So be very cautious about adding people, even kids, onto your deeds, okay? There could be potential tax problems and creditor problems as well. Giving assets away, this is a plan that typically my older clients will engage in. Why not? Hey, I don't need this money. I don't need this stuff. I'll just give it to you, my son and daughter, with the expectation is if I ever need it, I know you're going to give it back to me or use it for my benefit. And I have a problem with that, mainly because of control. believe it or not, there are some circumstances where you give kids money in advance and they spent it already, or it's got caught up in a divorce or bankruptcy. So not always a good idea. And that could be a potential problem, particularly if it's caught up in their own divorces and you give them money. There's also, you could be giving them the gift of capital gains tax as well. And I'm always amazed when my fellow real estate attorney peers just kind of take a ticket number and add co-owners on deeds without really advising the client of potentially the capital gains problem by doing that, okay? So the problem you have here when you add, say, for instance, kids onto the deed, definitely an estate planning tool. Definitely they would be the owners upon both your husband's death. No probate, super simple. But the problem is that from a capital gains perspective, they inherit your basis in the property. What is the basis? It is what you purchased the property for. As we all know, that the IRS taxes you on your gain. So gain on business sales, whatever the value was, it's increased over time. Since the time you bought an asset, like a stock, time you sold it, there's a capital gains tax. Now, typically you don't pay capital gains tax on your personal residence when you sell it because you kind of have a safe harbor there as far as it not appreciating over a certain amount. But there's no safe harbor amount or threshold amount when you sell secondary property. So when mom dies and the kids get the house through a deed because they're co-owners, yeah, they get the house, but they also get what she paid for in terms of her basis back in 1972 for $25,000, and they turn around and sell it for $350,000, as most kids will do when you pass away. They'll sell the property. Well, voila, they get a $70,000 capital gains tax, which is a huge problem. Okay, if you organize or design the house to go to the kids, typically through a will or trust in this instance, there'd be no capital gains tax if they turn around and sell it, because the kids, without kind of going down the geeky tax analysis road, they get a step up in basis, meaning that now that basis, that starting point for capital gains tax, jumps up to the date of the approximate last spouse to die. So since most real estate wouldn't necessarily increase within the next couple of months after they sell the property, they pay zero capital gains. So in sum, be very, very leery of adding kids onto your deed with the perspective that they're going to get this because I want this to happen when I pass away. There's a better way to do it through a will or trust, okay, from a tax perspective. Let's take a look at the beneficiary transfer plan. This is what we have with 401ks. This is what we have with life insurance policies. You select your beneficiaries. I would recommend that you indeed check your beneficiaries. Far too many times I've seen ex-spouses on life insurance policies. I've seen no contingent beneficiary after surviving spouse, even though clients assume there might be one. And so you want to make sure you check those. And particularly if you have a trust, you want to make sure you integrate that into your trust as well, as I'll talk about in a couple minutes with your estate plan attorney and your insurance agent. Okay, very, very important. I'm not going to spend a lot of time on this. I've already chatted about it really, but in essence, if you don't have documents for incapacity, there's a very expensive court process that a loved one has to go through, which is open essentially to your family members to show up and contest. That has happened. I've been in quite a few of those. It poses a big problem. There's a wait period. There's a court process. It's not efficient and very expensive. Something that you don't want to go on the cheap on, right? So a $350, $400 power of attorney is so much worth the expense as opposed to possibly your loved one's paying $10,000, if not more, for a guardianship or conservatorship hearing. Okay, so very important when it comes to that. Guardianship, by the way, is control over the assets. Maybe just need to control mom's assets in incapacity. Conservatorship is control over the assets. The guardianship is control over personal decisions like medical. Okay, most cases I'm filing for both guardianship and conservatorship because those decisions all need to be made. DC updates to the power of attorney and advanced medical directive. If you have existing documents, they need to be updated. My rule of thumb, and again, every practitioner has their own rule of thumbs, but my rule of thumb is you want to refresh those documents even if you're not having agent changes every 5 years. That's because, without going on a tangent, these documents, particularly the power of attorney, tend to have a shelf life. It makes no sense legally; it should be valid until you pass away. But some banks now have stipulations where they will not accept the power of attorney if it's over a certain amount of years old. In many cases, the advancement of directive could be the same way. So, a fresher power of attorney, even though it doesn't make any legal sense, it makes them feel better accepting it in terms of a more recent date as opposed to an older date, because that limits their liability in terms of a gap. Maybe mom signed another power of attorney that may come into play the day after, and we've got a liability issue on our hands. So, particularly with all the legal templates that you can do online and the AI now that produces, basic powers of attorney, you want to make sure that your attorney does it. These are not basic documents anymore. Banks understand that, and that's why, for instance, they're so particular about accepting them. Also, your documents typically want to have a medical release, not just with medical records release through HIPAA. That's just not with the advanced medical directive. Your power of attorney needs to have that as well, because if you have long-term care insurance, there's a medical weave in with that, along with the financial, in terms of a loved one, if you're incapacitated, activating any long-term care insurance through the power of attorney, not the advanced medical directive. Side note, your attorney should have updated your documents to update around COVID and pandemic-related issues. So in sum, before I move on the trust, you want to make sure you've got a will, which I'll talk about in a minute, 3 documents, at least a will, a power of attorney, and an advanced medical directive. The advanced medical directive, making decisions medically speaking, also the power of attorney making legal and financial decisions for you. I'm not going to get into the exact details of how they work. They come in a variety of flavors, and that is something indeed that you would talk to your estate planning attorney about, okay? So very common, and the clients I serve in DC, usually they're from other jurisdictions, and they've got old jurisdiction-oriented documents, and they need to be updated. DC is vastly different than a lot of different states. DC has a separate, much lower estate tax as well than the federal rate. So a lot of people that have kind of gotten a pass, not really concerned about estate taxes, they kind of get a rude awakening because they go in DC, live in DC, and they realize, oh my gosh, I actually have an estate tax problem at DC, and my documents don't reflect that at all. So that's something you want to, again, talk to your estate plan attorney about. So lastly, everybody needs these 3 key documents, right? Even if you kind of jerry-rigged your estate through having beneficiary designations on them, because I will say that although you can, and I say jerry-rig mainly because I'm not a big fan of relying on beneficiary designations alone, but it is effective. You might have beneficiary designations on all your assets, but typically when people pass away, it's not the cleanest thing in the world. And there are old documents, old assets that pop up. There's a check that comes in the mail. There's some power company that wants to see a qualification of an executive or administrator to deal with the lights and all this other stuff. So you at least want to have a will, okay? Because the will is going to be the backup document. Again, if nothing goes through the will, as far as assets that your loved one's going to rely upon to kind of clean up anything else that may come down the pike. The power of attorney and the advanced medical directive, all key. Now, the will is a document that we most think of. We're sitting on the tarmac in the airport, and we're waiting to lift off, and we nudge our spouse, and we say, "Hey, we really need to get our estate plan done." And that's kind of the last. It's not a good time to do it. That's usually when we're kind of thinking about it, right? So this is the document we mostly think about, the will plan. It's a written document. Unlike having nothing, it allows someone to make decisions for you, i.e., you get to appoint, not a court, who's going to step in and manage the estate. You, not a court, decides who's going to get what and do what. So it's very, very important to at least have a will, okay? Also, as well, the problem with relying on a will, oftentimes, particularly if you're married and you both pass away, or if you're single, in many cases, that will has to go through a probate estate. So the problem with a will, even though you get to choose who does what and who gets what, the overarching problem is, oddly enough, it still goes through the same process legally if you didn't even have a will, and it goes through a legal process called probate. Okay, that's when the will is set to court. Personally, whoever steps in as executor has to step in and raise their right hand and swear they're going to fulfill the duties of the will in terms of what it says. Debts have to be paid, and all that's paperwork, right? So there's accountings that have to be filed, there are bonds, insurance that have to be paid. The quasi person who oversees it, called a commissioner, gets a percentage of the estate as it goes through probate. So I'm telling you, you need a will, but as you'll see as I talk about trusts, wills are not the most efficient process to handle your estate, right? You have probate fees, taxes. It's going to hurt my ears, of course, but you should design an estate plan where you negate the role of lawyers. There shouldn't be lawyers in your estate plan when you pass away, okay? And it hurts me to say it, but you really should design a plan where you negate lawyer activity, negate the extra work a CPA may have to do, all of which typically are involved in these wills through this probate process, and in many cases takes months or usually years from a paperwork perspective to finally settle out. It's all public, by the way. And so you may not care if your nosy neighbor knows how much your loved one paid for funeral costs or what debts you have. But I, for one, don't really want that, right? So, that's why, as I talk about in a couple of minutes, I think a private trust is better because it doesn't go through that public record exposure. When I'm in a physical class, I show the wills of famous people, and then people often ask, well, how do you get these wills? Aren't they private? Gosh, there's a lot of detail in here. Robert F. Kennedy Jr., you can see exactly what he gave away here as far as personal property. That doesn't seem right. How'd you get it? Well, I just went online. I mean, it's very simple. And just like I can do with them, I can go online and pull up your will. I can pull up the accountings. I can pull up everything. Who got the Hummel collection, for instance. And so typically the probate process is public record and a bit, in my case, in my perspective, very nosy and intrusive. Probate clearly has control over who and how the will is interpreted. This is where I have to say, when you do your own plumbing, meaning you create your own estate plan, this is where it gets really murky, because a court may decide the way you wrote it is something entirely different from what you meant, right? So, there are two Latin terms. I'm not trying to flex on my legal knowledge at all, but there's two terms called per stirpes and another term called per capita. So unless you're a geeky lawyer like me, or someone who maybe just is interested in estate plan in general, you're not going to know what those terms mean. Those terms typically are what most jurisdictions use to determine who gets distributions, right? Per stirpes distributions are different than per capita. Why are you relying on willandtrust.com, LegalZoom, or even AI? By the way, I actually went through AI and ChatGPT, and I had them design an estate plan for me. And it wasn't that bad, but even ChatGPT, even artificial intelligence says at the bottom, probably should go see a lawyer to make sure this works. So again, you really want to make sure your documents are drafted by preferably someone who practices in this area, okay? So again, you want to make sure if you have a will that you really vet that through, whether that's the best plan with your attorney. Oftentimes people appoint, particularly in DC, out-of-state executors on their will. That requires, in many cases, extra hoops because they're out of state. Again, trusts are much more effective in this instance, as I'll talk about, because there's no requirement for that. But understand, appointing an out-of-state, out-of-district executor could cause additional problems, additional paperwork that may be filed. I'm going to spend a lot of time on minor children. Again, I would suggest you talk to your kids about what plans they have as far as setting up maybe trust for the kids and or who might be the guardian, okay? Let's talk about the trust. In sum, trusts are, if I put a trust and will side by side, they basically read the same. One says trust, one says will. And this is why when I present this at Osher, I have the kind of tagline, do only the rich have trusts? Because it's a misconception, even among professionals like financial planners and CPAs and others, that think in their minds, well, you don't have $1 million. I don't know why people just come up. It's always $1 million. I don't know where they get this amount from. It's not a tax code. It's nothing that we follow as estate plan attorneys. But that's in their mind subjectively. Oh, you're not wealthy. You don't need a trust. And most trusts that we draft as estate plan attorneys, to be honest, aren't fancy trusts. They're really trusts to be wills, but in order them to design to avoid probate, okay? So if I put a will and a trust side by side, a typical trust, they read the same. The terminology is different, right? One says will, one says trust. What's the difference? Well, the trust avoids probate when you pass away. Innately, that's a huge advantage, right? No filing fees, no requirement for your out-of-state executor or trustee to come to the state and personally appear and qualify. No need for accountings. No need in many cases to lawyer up and get guidance from a lawyer in terms of the probate estate or to pay a CPA greater fees because of an accounting that might be due. Trust also handle your estate assets really well, better than a power of attorney alone if you become incapacitated. I've had some trust where mom became incapacitated. That trust is 15 years old. Daughter walks in with a letter of incapacitation and a moth-eaten, coffee-stained trust, and the bank asked no questions. They accepted. They would not do the same if the daughter walked in with a power of attorney that was that old. She most likely would have to get a court order at great expense. So I don't feel like a trust or promoter enough to deal with assets and incapacity as anyone who practices in this area, particularly on the elder law side, as we do, many months we're planning around incapacity issues than we are death. Why? Because senior clients are living longer, but in many cases not better. They have Parkinson's, they have dementia. And so the planning needs to be there to be able to handle those assets accordingly. Trusts do a better job as well, better than an advanced medical, a power of attorney. Real quick, I'm kind of a history geek. Trusts are really created through kind of the Crusades, right? Crusading knights went down to the Holy Land and placed in trust their assets. Actually, one of the first banking systems, as a side note, you even see churches still being held by these old ancient trusts, believe it or not. Wills are more of a recent creature of the King of England. As you well know, particularly we live on the Eastern Seaboard, generally English colonies. We transferred the English common law over to the colonies. And, the King of England, with all those wars against France, got a very expensive. What a great concept. Let's tax people when they die. And thus the probate process was created. Also a great way, because it's public record, right? Also a great way for the king to kind of see and seize assets that maybe people he didn't like or maybe just decide not to like after death in order to get, their money for the royal coffers. So just as kind of a history point. So trusts are older than wills. What is a trust? I'm not going to complicate this because it's not complicated. All trusts are boxes. That's it. And there are two types of trust in life. There's revocable, which is usually the trust we draft as estate plan attorneys. It's kind of like a will. You can revoke it, you can amend it, you can do whatever you want to in the trust. And there are also trusts kind of beyond the scope of this presentation called irrevocable trust. That just simply means, well, there's some part of the trust that's irrevocable. I can't change, I can't do something. But that's it. That's all trusts are. They're boxes, right? And so, well, how does the trust then, if I put the documents between a will and a trust side by side, if they're basically the same document, how does a trust avoid probate and the will doesn't? Well, it's very simple. When you go to your estate plan attorney, you sign that trust document, you've essentially created an empty box. And that empty box is the trust. So for instance, my particular trust is called the Burton Trust, okay? And I'm in my own little trust as my trustee. And so it's empty. So if I open up a box in front of you right now and it's empty, well, the box isn't doing its job, right? Boxes by their nature need something in them to be effective. Your trust as a legal box needs your assets in it in order for it to bypass probate, right? How do we do that? So when you sign the trust with your attorney should give you something called a summary of the trust, or i.e. a certificate. A little certificate you take down to the bank and you say, hey, I got this trust. I just simply want to add the name of my trust to my bank accounts. I want to add the trust name onto my brokerage account. Nothing changes. The statements now read the trust name above your name. You still own it. We're just adding or tagging the trust name to assets. All your personal property would be assigned to the trust. That's highly advantageous. And usually, if your attorney is doing a good job, they will have a deed for you at signing that you can sign, adding or tagging the trust name to the deed. With revocable trusts, for instance, which is primarily what I'm talking about, which is most people have, quite honestly, there's no interaction or problem with your mortgage company, for instance. We're not changing ownership. So it's very, very simple. So the point is, when you sit down with your lawyer, you need to make sure you hold your lawyer down to kind of brass tacks in a way, just go over all your assets to make sure you have a clear understanding of which assets you may want to place into the trust. Or like life insurance, maybe you place the trust as a contingent beneficiary after the spouse. You need to be able to have that guidance, because so many times I see individuals with great trust, great binders, pretty binders actually, with their trust their attorney gave them, but they walk in and they have no idea what I'm talking about funding the trust. And that's a shame, because you've got to make sure you keep those assets in the trust. Simple to do, but make sure you have it done. So once you have all the assets in the box, if I pass away, I have a successor trustee that pops into the box. They, at that point, like a will, pay debts, expenses, and distribute out. Now, in many instances, because I have kids, I have little mini boxes that appear after death that I have an independent trustee managing their little trust for them up until certain ages, right? And so that's the advantage. You can kind of continue on your trust, split it up into little mini trusts for kids, even grandchildren, maybe in this instance for most of you. And you can dictate the tempo privately of how those assets are managed for my kids, right? If I want to put an educational incentive in there, I could do that. If I say they have to have a degree in underwater basket weaving at least, or if not, they get everything at age 45, then I can put that in my trust agreement, and it's legally effective. Okay, so a comparison with a living trust, so long as it's funded, you get assets in the box, there's nothing that should go through probate. Okay, and the great thing about the trust as relying on beneficiary designations is that you've consolidated the assets out in this particular box when you pass away, meaning whoever steps in as trustee now has the money to be able to pay your just debts, taxes, or funeral costs. If you kind of spray out your estate through beneficiary designations, yeah, the kids get it. But what if one child doesn't want to pay half of the funeral cost? What if one child says, well, I know mom has some tax debt for the amount of months she was alive, but I'm not going to give you money to pay it. So again, you can't really rely on beneficiary designations in my mind as a consolidated plan if you're married, when both of you pass away, or if you're single when you pass away, because you just have so much more consolidation benefit of assets in a private trust. Typically, you want to make sure you place your house into the trust, bank accounts, your taxable investment accounts like brokerage accounts, CDs, money market accounts, and the like. Typically, we never place IRAs in the trust while you're alive, although depending on those circumstances that you would vet through with your lawyer, we do sometimes recommend the trust be a beneficiary of the IRA. Maybe you're setting an IRA trust up for your spouse that kind of protects against their remarriage. Maybe you're setting up an IRA to go to your kids because you want to set up the IRA when you pass away to go into these trusts because you don't trust them with the money. Otherwise, you would just list your kids as beneficiaries after that. So that might be those particular investments or retirement accounts we may leave outside the trust depending on what the ultimate plan is, okay? Again, so important to vet these types of funding issues with your attorney, okay? Just don't walk out the door with the attorney from the attorney's office with a nice binder. You want to make sure you understand what you're doing, okay? And there's follow-up there as well. There's no restriction on these trusts, right? So you can buy and sell assets as before, change it and cancel it whenever you want. Good thing about the trust plan, typically I find, as opposed to the will plan, trust plan is so flexible. You can add amendments over time. So 2-3 pages, you're changing trustees, you're changing who gets what. It's very simple to maintain and update. Trust also can protect or shield your assets from lawsuits, creditor claims, and Medicaid spin downs. which are, very, very important. I'll talk about that briefly. For the host that's here, I've been tracking my watch, but can you give me an idea roughly how much time I have so I can pace myself?
Sure. So it's 6:17. What do you think? Maybe another 5, 10 minutes? We only have one question so far, so
Okay. Okay.
yeah.
Yeah, absolutely. So I'll stop in the next couple minutes or so. I have more slides, but I just wanted to make sure I talked about everything I could within the time span I had. So
We're happy to invite you back.
I can't. Perfect. Good. Thank you. So with your inheritance, you can plan it out all at once. You can make it go in installments, income only, lifetime for the beneficiaries. Particularly important if you have a grandchild or a child with special needs. Trust can be set up after you're gone to protect the assets against inclusion into maybe Medicaid benefits they're receiving, some benefits they might be receiving from Social Security disability. So that's a consideration. They would not be disqualified. And you also can establish dynasty trust where it kind of rolls from one generation to the next. That's great for asset protection. Also great to make sure your estate's not watered down among beneficiaries that you never knew. There's some estate tax planning perspective in there as well, protections. And so lastly, I want to just go over the last celebrity example and we'll open up for questions. Elizabeth Taylor, so we all know, honestly, she kind of had a dumpster fire as a personal life between all her multiple marriages, but she had her act together when it came to her estate plan, okay? She had a trust. And so when she passed away, everything passed seamlessly with the trust agreement, a private trust. And that's why you can't Google her will. That's why you can't Google up assets in terms of who got what and what the total estate value was. Although I'm sure people are nosy, I'm sure you could probably find some estate value on Google. But ultimately, she didn't rely on fate. She didn't rely on the code. She didn't rely on a will plan. She had an effective trust. So lastly, you don't have to be Elizabeth Taylor, a celebrity, to have a trust. Most people that have trust, it's basically a will replacement trust. Does all the same things a will does, but it bypassed the probate process. Lastly, for residents in DC, you want to make sure you talk to your attorney about the DC estate tax, okay? Because it doesn't take long or in terms of garnering assets, particularly if you have a residence in DC, to get over that threshold, okay? So you do want to make sure that you have proper planning in place to deal and maximize what you can pass on estate tax free to your heirs. And so again, this just summarizes what I talked about concerning the living trust. If I am able to speak to you again, I would talk about asset protection involving trusts that would shield assets against lawsuits, creditor claims, and Medicaid spin downs, along with some other estate tax planning mechanisms as well, not to be too detailed in that. But I think this is a good summary of what I was designed and asked to speak on this time. And so with that, first, I want to thank you for allowing me to speak. And again, as a favor to everyone participating, I'm more than happy to have you send an email, call the office. And in fact, I'd offer a free consultation to any of you in terms of reviewing your existing plan, at least discussing via Zoom, in person, or over the phone, some of your estate planning questions. And with that, I'll open up the questions.
Thank you, John. So before we open it, let me ask you a couple of questions that have been in the chat.
Sure.
And we can run a few minutes extra, as I mentioned. Do you want to stop sharing? So it sometimes might be easier to see people. If
Absolutely. Sure.
Thank you. Thank you. All right. So nice to see everybody. The first question came from one of our fabulous volunteers. Julian wanted to know, are assets covered by transfer on death beneficiary designations, example, IRAs, are they assessed the percentage fee for probate or only those assets disposed of by a will?
Yeah, great question. So generally speaking, if you have beneficiaries on your IRAs, that is not a quote probatable asset, meaning it does not go through probate. Practically speaking, how that would work is that your beneficiaries would call, say, the Fidelity or Charles Schwab, wherever it's managed, or the custodian would be, and you provide the death certificate, your information overall, and then they would establish, if you prefer at the same institution, an inherited IRA. And so that portion, that percentage, or whatever is designated within that designated beneficiary form, would roll into, if I'm the child, it would roll into my name as, say, the John Burton inherited IRA. And if I kept it in an IRA, then I'd have to liquidate it under the new Secure Act rules over a 10-year period. Okay, so as you may all know, the rules have changed when it comes to inheriting qualified plans. Used to be a longer time that you could the beneficiary could stretch out the tax hit. Now the government wants their money sooner, regardless of who's in charge. And so they make the beneficiary, absent some exceptions, extinguish or liquidate the IRA fully, pay the tax within 10 years, typically is a year-by-year calculation in terms of withdrawal, which I won't get into. And I cannot hear you, by the way, Lynn.
Ah, that's because I was muted. Thank you.
Sure.
So the next question coming from Elise is, what are the pros and cons of setting up a trust in another state? So if a DC resident, for example, is setting up a trust to be based in Delaware, I guess they would have a property in Delaware.
Well, yeah, that's very interesting. And that's almost a presentation in itself. I will say there's typically no prohibition against creating trusts in other states. In fact, I practice in Virginia, and there are many out-of-state individuals that choose Virginia as a situs or location for a trust. Different states have different benefits, different laws as it relates to trusts. In some cases, like Delaware, for instance, Delaware was very progressive about asset protection qualities of a trust being held by there. There's also some tax benefits as well. So you can establish a trust out of state, but again, you definitely want counsel by your lawyer in terms of dictating if that's even necessary. So people Google and it's like, oh, well, that seems so cool. I want a Delaware trust because my friend has one, but it may not be the best particular option for you from a estate planning perspective.
Thank you. Okay, the next question, Teresa would like to talk about the letter of last instructions.
Yeah.
I don't know if you want to start with that because this is a multi questions. The next question also from Teresa is it better to have a friend as a trustee or a financial advisor firm?
So the first question, I don't really know what that means. I mean, there are various different legal terms for the same thing. A letter of instruction might be relating to personal property. If that's the case, for instance, the trust is a better way to handle that because you can designate privately where certain assets go. Letters of instruction also may mean just preferences in terms of how your trustee manages the estate. May not be necessarily legal, but may just be guidance oriented. So there are different types of letters of instruction. So I don't know if I touched on any one that perhaps you were thinking of. As it relates to the second question, could you just repeat it one more time, please?
Sure. The question is it better to have a friend as a trustee
Right.
or or to use a financial advisor for your trustee?
Well, I don't mean to sound like a lawyer, but it depends. It depends on typically, I will be honest, most people do select a family member to be a trustee because it's a trust variable, you trust them. I will say it may not be the best selection if they can't add 2 + 2, or maybe they're not very responsible in terms of being financially oriented. So another option would usually be maybe a trust company. It could be the lawyer themselves serving as trustee. It could be a bank. Sometimes institutions will be trustees corporate-wise. And again, those types of decisions you would vet with your lawyer because there are pros and cons to all of them, okay? Normally, your financial advisor cannot be a trustee of your plan, whether will or trust, because it's conflict of interest from their compliance department typically. It's a conflict because they're managing the money for you, because they're managing the money, collecting the fee. Generally speaking, they're not permitted to also be the trustee and executor. So those are really your three options. Family members, of course, friends, attorneys, sometimes CPAs will be appointed, whether trust or in a trust as a trustee role or executor or institutions.
Thank you. So moving on to the chat, and then we'll open it up to the room. Um, if a spouse is not a US citizen, would the trust be drafted differently? And as a follow-up question to that one is, can assets in a foreign country be included in a trust?
Yeah, so the answer to the first question is yes, it is drafted differently. There's certain provisions, particularly on the estate tax planning side, that we would install. So that is a yes to that question. The other question, I'll sound like a lawyer again, it depends. So international, I do quite a few international planning techniques, whether it's establishing offshore trust corporations and those types of things, maybe Cayman Islands, Cook Islands, another option. But it depends. It depends on in some cases, the treaty between the United States and the other country. In some cases, it depends on the asset. In some cases, it's better just to have a separate estate plan in that particular jurisdiction. If it's just real estate, for instance, a lot of times you might have a German will that may cover it. And if it's pretty simple distribution pattern, not a lot of complications or controversy. So again, something that you'd want to talk to your lawyer about in terms of designing the best plan when it comes to offshore assets.
Great, thank you. And so now I'm going to open it up to the floor. Tony, I see you unmuted. Did you have a question?
Yes, I have a question.
I thought you might.
I have several questions. I have a newly written will, which basically through many, many pages and much verbiage just dumps everything into a trust.
Yes, yeah.
It does have a list of gifts that I want to make. That is in the will. But the most of my assets have been moved to the trust.
Perfect.
I have two questions, but I think the one that applies to everybody is when she finished the trust, she simply handed me a sheet of paper that said memorandum something, something, something. And I think I'm supposed to list on that every piece of valuable items that I care about, I guess, and that I want to designate to certain people. Obviously, they can't, either or they all get sold, if possible, and divided up among my 4 sons. And I think all my other assets have been allocated as being owned now by me with called revocable Antoinette Russin Revocable Trust.
Yep, great job.
Does that sound correct?
It does, yeah. So I didn't mention this for the sake of time, but when you establish a revocable trust, your attorney will draft a will for you, right? So despite my disdain for wills, usually we have to give you a will with your trust. And the reason is this. So some people are not diligent when it comes to their trust. You seem to be, but if you don't take the active step to go down to the bank to contact your broker and add the name of that trust or that account, that's not in the trust, it's not in the box. So generally speaking, we try to kind of make sure we safeguard our clients' assets at death. So we give them something called a pour over will. So that's what you have.
That's what it is.
So it's really not a will in the sense it designates, traditional will designates beneficiaries and distributions. That pour over will just says, look, it doesn't, say look, but it says if I pass away and I leave an asset outside the trust and it doesn't have a designated beneficiary, I wanted to go to my trust anyway. So it's like a 3-page, 4-page document. Your will seems a little longer than that. But the trust will be the beneficiary of the will. That's I call it the break glass document, meaning hopefully it's never have to be used. Hopefully that's will always remain in your binder because that means you left something outside your trust when you passed away. And your will probably doesn't say pour over will. It just says last will and testament. So that's why it's kind of confusing because a pour over will is kind of estate planning slang. It's something we don't actually put on the document. I hope that your memorandum doesn't say something on it because that would be not very funny.
I'm not looking at it.
But so that memorandum is typically something we give you with your trust document. And the memorandum doesn't mean you have to itemize everything. That memorandum is in place for you to handwrite certain items to certain people, right? So, clearly some items you won't even list, you signed a summary, a document called personal property assignment that assigned all your personal property to the trust when you signed the trust agreement. But you have the ability, and this is, I think, more efficient in the trust, to designate where certain items go. And you can change that whenever you want. It doesn't have to be notarized. It doesn't have to be witnessed. So you don't have to pay a lawyer to do it every time you want to change. But that's what that memorandum's for.
What if you own, um, what if you own an LLC? I've inherited an LLC, which is the owner of a property in Moscow, Russia.
Yep.
My attorney basically said, sell it if you possibly can, because it may get complicated. But if you own an LLC, what happens?
So typically what we do with an LLC is that I normally have my clients sign something called an assignment. An assignment really is like a tether. It's a legal tether that would say, look, if I pass away or become incapacitated, whatever interest I have in the LLC or corporation, that will vest to my trust. And that enables your trustee to deal with it immediately, as opposed to having to go through probate in order to actually have access to the LLC. LLCs and corporations or businesses are very complicated going through probate. So sometimes the commissioner wants evaluation on the business interest. So if you can avoid that by having that tether or assignment into the LLC, I know it has foreign assets into it, but I'd have your attorney readdress that issue to see possibly if that might work. If it's domestic American LLC, then you can definitely establish the tether regardless of what it owns. So I would touch base with them on that.
Okay, thank you.
Thank you. I see, Teresa, I see you've now raised your hand.
Thank you. First of all, this is fantastic. It's really, really helpful. And I've had a living trust drafted 20 years ago. I was very sick a few years ago. So I had my lawyer review everything and we had to start from scratch. So it's absolutely true. You have to update that from time to time. So I still have some questions, even if I know what it's all about. And my biggest question is, can a trustee be also a beneficiary? And in that question as well, do I need to compensate the trustee? So in cases, for example, family member that I want them to be a beneficiary, could they also be a trustee, or is there a conflict of interest?
Question. So it's very common, particularly when you have kids, that clients will put their kids on as trustees. I don't necessarily think it's necessarily a good idea to have a sibling manage another sibling's money, but in some cases it works. So there's no prohibition against that. Now, if you, sometimes clients will add, and this is much more readily available in a trust, you can actually add something called a trust protector. And it's kind of cool. So you could say, well, this person will be the trustee, but I want them to have kind of someone kind of watching over them at a 30,000-foot level. And that trust protector is not a trustee. They don't get a fee, but they might be in this case, maybe the financial planner, might be the lawyer to kind of guide them, maybe act as a buffer between siblings, right? It's always easy to blame the lawyer than it is, someone else. So sometimes the lawyer may serve as a trust protector. These trust protector clauses, like going on a tangent, can be drafted in a variety of ways, and they're kind of cool, and they're relatively new to trust planning. And so when it comes to a fee, usually your trust, if you comb through it, you will see a provision in it that dictates what type of fee the trustee will get. So trustees get a fee innately. Generally speaking, a trust with a trustee would normally get about 1% fee. That it's kind of a sliding scale. So it's over so many millions of dollars that the fee drops down and flexes in that way. It's much lower than, say, a will. In a will plan, typically they can earn anywhere between 3 and 5%. So you are saving money, just in the kind of back end by having a trust as well, appointing a trustee. But normally that language should be embedded already in your document, and it may not have a number, because in most jurisdictions it's kind of what the trustee has the ability to charge a reasonable fee. And so what does that mean? Well, usually it tracks what trust companies and banks are charging, okay? And normally that's about 1% overall. So that's kind of the guidance I can give to you.
All right.
Thank you.
Thank you so much.
So we have another question in the chat asking, and I'm sure this varies from estate to estate, but the question is, what is a typical fee for drawing up a trust? So if you could give us a ballpark, I promise on behalf of the group here, nobody's going to hold you to it. How's that?
Oh, okay. We'll see about that. No, just joking. Yeah. So typically it depends, right? So again, not to kind of sound like a lawyer, but it really depends on, for instance, what we're drafting. It depends on what type of trust we're establishing, maybe for kids after the fact, after you pass away. It depends on the assets that may be going into the trust, how many deeds you have, how many deeds we're preparing. On average, for single people, it could be between $3,000, $4,000 for the whole plan. Remember, it's just not just the trust. It's a trust summary. It's the personal property assignment. It's a power of attorney. It's the advance medical directive, and that pour over will as well. So there's some other documents that go along with it. So it is a complete plan in that way. For married couples, it can range anywhere between $4,000 or $5,000. And again, I'm just kind of giving you fees that I'm kind of used to charging. And some attorneys may charge more, some attorneys may charge less. If it's too far less, I'd be a little worried. But on the same token, it does vary between law firm to law firm, but that's typically what you can expect.
Thank you. I'm not seeing any other questions. I'm just looking around. If anybody else has a question, now's your opportunity. And I guess not. So John, thank you so much for your time. I really appreciate your generosity of time and sharing all this information.
Oh,
I will be getting back to you. I do think this would be great to have a part 2. I think, as you mentioned, there were other things you could have covered, and I think clearly there's a definite interest. So I'll warn you now, we'll be reaching out and saying, please come back. And again, I really do appreciate the time, and thank you all for attending. Exciting news, in March, our CCC program is going to be presented by Tevi Troy, who you might remember the name from, I believe it was the Bush administration. And he is a local, he lives locally, and he's going to be doing an online presentation on his new book called The Power and the Money. So that should be a very interesting presentation as well. We invite you all back, watch your emails, watch social media. We go out there when we invite you, and we hope you'll join us again in March. That'll be March 12th. So again, John, I thank you, and I look forward to seeing you again. Thank everyone for attending.
Everybody have a great night.
Thank you.
Thank you.